you have thousands and thousands. Matters disposed of it. Here it's 11,661 complaints. Okay. Now, what can we tell from statistics? Well, the statistics are very limited because the question is, are those dismissals appropriate? Are they correct? And to make that evaluation, you need to see the complaints. You need to see the complaints, and you need to compare them with the dismissal letters. What did the dismissal letters say about the complaints? And is it consistent?
Well, you have about 1 minute remaining.
Oh dear. Okay. All right, so let me very quickly tell you. In 1989, the state controller tried to do an order to the Commission on Judicial Conduct, which wouldn't allow the controller access to its files. The controller knew that without access to the complaints, the record of complaints, and the dismissals, he could make no assessment as to the legitimacy of the dismissals of complaints. The Commission wouldn't give access, and so he wrote a report called Not Accountable to the Public. You have no auditing in all these years. There's never been an independent auditing of the complaints filed with the grievance committees. You're not in a position to do an independent audit, but I will, since my time is up, I will. Okay, I want to just leave with all those who have testified should be providing you with their complaints. I have brought here a sample, an illustrative sample of, let's see, 5 here, 5. Okay, and I have additionally, I want to say that the important law review of Professor Gillers, which really gave rise to this commission, as powerful as it is, it's flawed. Why? Because it never goes beneath the surface of the judicial decisions. And the judicial decisions, over and again, like the dismissals of complaints that are not really by the grievance committee but by staff, are fraud. And you can discern them by examining the case files. Here is the case file. As to the unconstitutionality of New York's attorney disciplinary law, you may be sure.
Thank you very much.
Well, I just want to say.
Do you have any questions?
Because Mr. Zotterer asked another important question at the Albany hearing.
Your time is up.
And I was not. Would you repeat the question to me that you asked the president of the state bar?
Sorry, I don't know what you're referring to.
May I remind you? Thank you, sir. He asked me to remind him. He asked me to remind him. Thank you. Like Professor Gillers. Okay.
Please.
Mr. Zotterer asked the president of the state bar, who spoke on.
Let her finish. Let her finish.
He asked me to respond to the question that he asked the president of the state bar in Albany at the first hearing, because the president of the state bar had testified about introducing discovery into attorney disciplinary proceedings. And the state bar has issued a report. Mr. Zotterer, because discovery is such a fundamental thing, it's a matter of due process, confrontation rights. And Mr. Zotterer asked the intelligent question, well, what is the opposition? What could be the opposition to discovery? And believe it or not, the president of the state bar fumbled and was not really able to answer that question. And I I tried at the end. I said, I have the answer. And so now I'll give you the answer.
Briefly.
The answer is that in all the decades that we have had this attorney disciplinary regime, you may be sure that prosecuted attorneys have made motions and sought appeals and have raised the constitutional issue, among others, of their entitlement to discovery. They've raised it before the appellate division. They've raised it before the Court of Appeals. If you look at the records, the files, case files, and of course the case files, once an attorney is publicly disciplined, disbarred, or suspended, those files are all open to you. Okay, you have no bar. What you will see is they make the constitutional legal arguments. And the response from the court, denied. There's no discussion, no elucidation. There's nothing, and that's why there's no case law. And if you look at the report of the State Bar Association to you on the issue of discovery, it's in a vacuum, just like Professor Gillen's article.